Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala sayidina asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Alhamdulillah. Thank you everyone for coming to this webinar entitled Aftermath of Nick Elin versus State Government of Kelantan, a way forward in coping with gender dysphoria issues. I'm Dr. Zahid bin Zamri, the head for research and publication. Research and publication at the Office of Islamization, Integration and Relevantization, Center for Islamization, UM. I welcome all of you again to this webinar. We have two distinguished speakers. Alhamdulillah, we have the first speaker is Datuk Dr. Mazuki Muhammad, who is an associate professor in the Department of Political Science, Abdul Hamid Abu Sulaiman, Kuliah Islamic Individual Knowledge and Human Sciences, IIUM. He started his career at IIUM as a law lecturer at the IIUM Articulation Center in 1999, before joining the IIUM Political Science Department in 2002. He obtained his LLB honors from the IIUM in 1998, MA in Political Science from UKM in 2001, and PhD in Political Science from the Australian National University in 2008. Between 2009 to 2020, he served the Malaysian government in various positions on secondment from the university. His last position in the government was Principal Private Secretary to the 8th Prime Minister of Malaysia. Welcome, Datuk Mazuki. Thank you for coming.
Thank you, Dr. Zaid.
Okay, so we have the second speaker. The second speaker is Dr. Nur Razina. Dr. Nur Razina Muhammad Zain. Okay, is currently working as an assistant professor of laws at IIUM Institute of Islamic Banking and Finance, or IIBF. Yeah. She received her LLB honors and Masters of Comparative Laws and PhD in Laws from IIUM. She is also an advocate and solicitor of the High Court of Malaya, non-practicing. Since 2014, she worked with ICOL, Ahmad Ibrahim Kuliah of Laws, Harun M. Hashim Law Center, and Kuliah of Economics and Management Sciences, KNMS. Her specialization focuses on comparative banking laws, Islamic banking and finance, alternative dispute resolution, business law, and sustainable finance law. She is the Islamization of Human Knowledge Coordinator at IIBF since 2020. She has contributed in several research projects from 2014 to 2023. She has written more than 70 research works, including articles, chapters, and books. All right. So, Alhamdulillah, today we have two experts to talk about the issue that we currently witness. All right. Recently, as we perhaps have read and have witnessed, the issue of Sharia laws in Kelantan, all right, being challenged by Nick Elin and perhaps her supporters to say that there are redundancies, all right, within the state Sharia laws and the federal laws, all right, the constitution. So today we want to discuss from the academic perspective, is it true that there are redundancies, or is it actually something that will harm Muslims, right, if we continue with these trends, or is it actually there's nothing to worry about? Actually, as we perhaps have witnessed, some scholars law scholars are saying that there's nothing actually this will improve. Okay, this will improve, will make it much more, um, much more. The constitution will be much more solid. Okay, so to speak, when Nick Ellie did that, all right, Nick Elin did that. Okay, meaning to say the Sharia court in Kelantan did that. So today, inshallah, we will discuss from that perspective. Actually, this discussion, okay, webinar is in conjunction. Okay, why gender dysphoria? Because centuries, inshallah, we are going to publish a book on gender dysphoria. Will be published at the end of the year, inshallah. So uh, we will get perspective from people from natural sciences, and we will also get perspective from people in human sciences to discuss on this gender dysphoria issue. So today we will discuss about, of course, the issue that I mentioned about the current revision to the Sharia laws in Kelantan, but we will try to relate the discussion to the issue of gender dysphoria in particular, but in general, we will discuss, all right, about other effects that perhaps there are any effects that may happen generally, okay, towards our society. So today, uh, that will be the focus, inshallah. Okay, so I think without further ado, I want to welcome our first speaker, Datuk Dr. Mazuki, okay, to deliver his presentation, and then the second speaker after that. Later, we will proceed with Q&A session. All right. Okay, Dr. Mazuki, floor is yours.
Thank you, Dr. Zahid. I would like to share my screen. Right. Can you see my screen? Okay. Okay. Assalamualaikum warahmatullahi wabarakatuh, and good morning. First, I would like to thank Dr. Zahid and Centuries for inviting me to speak at this webinar today on the Elin's case. For today's presentation, I would like to focus on the question of morality in relation to the decision of the federal court in Elin's case. First, what is it about? As we already know that in Elin's case, the federal court declared 16 sections in the Kelantan Sharia Criminal Code enactment unconstitutional. And this include offenses of sodomy, sexual harassment, organizing gambling activities, offering vice services, preparatory act of vice, incest, etc. So these are basically religious offenses. We know that in Malaysia, the state legislative assemblies, they are given the power to legislate on matters of Islam. And this include offenses against the precept of Islam and the Sharia law in Malaysia. They are administered by the Sharia court. And before Nick Elin's case, there were a few other cases that the court has declared a number of state enactment on Sharia criminal offenses as unconstitutional. One of them is the Ikiputra case, where the federal court has declared the sodomy offense in the Selangor Sharia criminal law enactment as unconstitutional. And before that, there was a case in the Negeri Sembilan where the court also declared um, the section, in the Sharia enactment of Negeri Sembilan unconstitutional for being inconsistent with the federal constitution. And how did the court arrive at this decision in Elin's case? Um, so in the federal constitution, we refer to list 2 in the ninth schedule of the federal constitution, which is known as the state list, where under the list 2 of the ninth schedule, the Constitution provides that the state legislative assembly has the power to make laws, among others, on the creation and punishment of offences by persons professing the religion of Islam against the precepts of that religion, except in regard to matters included in the Federal List. It's simply speaking that this is the way that the Constitution has divided legislative powers between the state government and the federal government. Because we know that Malaysia is a federal system. We have government at the federal level, and we have also government at the state level. The federal constitution has divided both executive powers and legislative powers of both levels of government in the ninth schedule of the federal constitution, where under list 2, the federal constitution listed certain powers that the state legislative assemblies can make law, or certain matters were enumerated in the list, and that includes the creation and punishment of offenses against the precept of Islam. However, under this schedule or list 2 of the federal constitution, if you notice the final words, except in regard to matters included in the federal list, meaning to say that the federal constitution give powers to the state legislative assemblies to legislate on matters pertaining to offenses by persons professing the religion of Islam against precepts of that religion, but it excludes matters that are included under the federal list. And it is quite tricky because in the federal list, crime is considered or is enumerated under the list or matters that the federal parliament has power to enact laws on those things. So there is a conflict there, whether when we say offenses against the precept of Islam, so we need to say Sharia criminal laws, then of course, that will also touch on matters that fall under the state, under the federal list, which is crime, like crime like murder, theft, or gambling, for example, which are also included in the federal list. So in Elin's case, the court has to consider whether when the Kelantan State Legislative Assembly legislate or make laws on, say, for example, gambling, whether gambling falls under the federal list. Now, if gambling falls under the federal list, by regard, these provision under the list 2 of the ninth schedule, except in regard to matters included in the federal list. The court or the federal court in Elin's case decided that, gambling falls under the federal list, so therefore the state legislative assembly does not have the power to make laws on it, even though that it is a precept or offense against the precepts of Islam. So therefore, the court held that the 16 sections are matters that fall under the federal list. Hence, the Kelantan State Assembly does not have the power to make laws on them. Now, what else did the court say? Other than declaring the 16 sections as unconstitutional, the federal court also says that the civil courts, like Sharia courts, administer ta'zir. So meaning to say that even laws that we know, even the court says is secular law, administered by the civil court, but the federal court says they are also ta'zir. So this is a bit problematic to me because ta'zir is an Islamic law concept, whereas civil law or criminal law or the general law on crimes, they are basically secular law. So how come ta'zir be equated with a secular law? So this is something that I found a bit problematic in the decision or the majority decision of the federal court in Elin's case. And secondly, the court also said, this is in the majority decision, the structure of the federal constitution leans in favor of secularity. So you can see page 42 of the majority judgment, leans in favor of secularity. So the court seems to incline to say that secularity or secularism forms the basic structure of the federal constitution. So this is another debate on the basic structure doctrine, or the basic structure doctrine of BSD, which originally mooted by some legal scholars in Germany, and later on it was adopted by the Supreme Court of India uh, 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 to make it easier to understand what basic structure doctrine is all about. It is basically the court, will determine what form the basic structure of the constitution. Say, for example, in Malaysia, for example, there are judges who say that separation of powers form the basic structure of our constitution, or fundamental liberties form the basic structure of our constitution. So therefore, any laws that the court feel that it is against, say, the concept of separation of powers or the principle of fundamental liberties, the court can say that that particular laws are inconsistent with the federal constitution and therefore void. Now, even though that there is nothing in the federal constitution that clearly stipulates the matter. In India, it has generated fierce debate, particularly between the judiciary and the legislature, because the legislature would then say that the court has usurped the power of the legislature in lawmaking. Some say that this is something to do with judicial legislation, where the court can just declare certain law as null and void, or for being inconsistent with the basic structure of the constitution, whereas that basic structure is not being clearly stipulated in the federal constitution. So to me, this pronouncement by the federal court to say that our federal constitution leans in favor of secularity, to me, in terms of its impact, is far greater than the decision of the court to declare the 16 sections as unconstitutional. Why? Because it is far-reaching. If the court says that the basic structure is secularity, in the future, any kind of laws or even executive decisions or policies that the court feels against the principle of secularism can be declared as null and void. So this is, I think, it needs another, discussion on this particular matter. though I think that it is very much related to Nick Elin's case. Now, what is the root of the problem? See, the root of the problem lies in the secular law itself, especially the understanding of legal positivism that does not accept state legislation on morality. They say that the state should not legislate on morality. Morality is a private matter that the state should not interfere into the privacy of individuals. So there is the concept of moral crimes, like, for example, adultery, drinking liquor, drug abuse, LGBT. From the perspective of Western secular legal what do you call this concept that these are all moral crimes. Adultery, for example, if the sexual intercourse is between two consenting adults, it harms nobody, so it should not be an offense. Or drinking liquor, for example, if someone drink liquor, he does not harm anybody else, so there is no victim there, right? Drinking liquor only become a crime when someone drink and drive. So it will probably harm others, when someone drive under the influence of alcohol. But if he drinks, at home or at bar, for example, nothing wrong with that, according to the Western secular liberal understanding of the law. Drug abuse too, and we can see that some countries have even legalized the intake of drug, because there is no victim if you just a user or drug user. LGBT is the same. In some countries, even LGBT has been legalized. Same-sex marriage has been legalized, or even someone who talk bad about the LGBT community commits an offense for hate speech, for example. So for them, from the secular views, that the state should not create punishment for victimless crime. So if you can see all the 16, offenses that the federal court has declared as unconstitutional in Nick Elin's case, they are all moral crimes. They are all religious crimes, right? And the root of the problem is also about secularization as a philosophical program. So if you read Syed Naqib al-Attas, his book Secularism, Islam and Secularism, for example, he talk about secularization as a philosophical program where man has been uprooted from religion. Nietzsche, for example, has declared that God is dead, and life is all about self, and values becomes very relative. So this is starting from Enlightenment period, humanism, relativism, so this is part of the process that you are facing. This is not nothing. This is not something new. What I'm trying to say that when we see Nick Elin's case, it is not isolated case. It is part of this particular process of secularization that has taken place for hundreds of years. If you read Syed Naqib al-Attas, for example, he has viewed that Christianity in the West, for example, has undergone this process and it has become a secularized religion. And I believe that Islam, and sooner or later, will also become, a secularized religion. If we don't do anything to stop this process of secularization as it is taking place in our country now. Religion is a private matter. This is another assumption, which I think this is also a root of this particular problem, because from the secular perspective, religion is a private matter. It doesn't mean that you cannot be religious. Yes, you can be religious, but keep it to yourself. You can become religious in private, but you can impose religion on others. What more, the state should not impose religious law or to make certain action as an offense, a religious offense. So this is a big no-no for the secular liberal, proponents of secular liberal and legal thinking. So, example, anti-moral policing campaign led by Sisters in Islam in the early 2000s in Malaysia. So this is not something new. It is about 20 years ago. This particular process has started in this country. I quoted this paper by Zaina Anwar, the executive director of Sisters in Islam, at the public forum organized by Liberal Forum Malaysia and Frederick Newman Foundation in Kuala Lumpur on 27 April 2005. This paper, the title of this paper is Enforcing Public Morality. And I quoted what Zaina Anwar wrote in this paper. And she said, Sis public position on moral policing did not begin with the recent Jawi raid. At that time, Jawi, the Jabatan Agama Wilayah Persekutuan, has organized, raid in pubs, nightclubs, and as a result of this, Sisters Islam launched a protest against it. And she said that SIS has been monitoring the Sharia criminal offences law since 1997, when 3 Muslim women were arrested for taking part in a beauty contest and charged and found guilty for violating a fatwa and for indecent dressing. This has generated a public debate not just over the way the women were arrested, but also over the very existence of a more expensive and punitive Sharia criminal offences law. So I highlighted that part, when she said that, those Sharia laws are expensive and punitive. And the offences questioned by Zainah, among others, are defying fatwa, insulting Islam, indecent manner in public or a public place, revealing aura, and failure to perform daily prayers. For Zainah, these are religious offenses. These are offenses relating to morality that should be left to the private individuals, to decide, not for the state to interfere by making them as offenses. And she further said, these are only a few of the areas of concern in the Sharia criminal offences law that we have called for review and repeal. So since the early 2000, that this group is already talking about, they have been talking about the review or repeal of those laws. But what happened was that, politically speaking, it will be quite, suicidal, politically, for the government to repeal, these laws, because, well, we know this is a Muslim majority country, and majority of Muslims in this country have quite conservative understanding of Islam. And if the government repeals this law, I think they will face the brunt of anger from Muslims in the election. So they won't do that. And secondly, the court, because the court, like in Elin's case, can review those laws. But the judicial attitude at that time was not quite friendly with this, secular, liberal, legal thinking. The judges were quite conservative then. Whenever this kind of a challenge was brought to the court, the court will say, well, Article 1211A, this comes under the jurisdiction of the Sharia court, and the civil court, will not entertain those, application. So they just they use, these conservative judges will just use Article 1211A, to protect, the Sharia courts. So their efforts to challenge, these Sharia laws were not successful then. And Zainah further asked, is it the duty of the state, in order to bring about a moral society, to turn all sins into crimes against the state? Should the state extend the long arm of the law to what should be best left to the religious conscience of the individual? I think this is the crux of the matter. If you look at Nick Elin's case, what Nick Elin was trying to do was just to say that, well, these are all religious offenses, these are all offenses relating to morality. It shouldn't be there in the state enactment. The state should not even think of, creating offenses out of those behavior, because these are all, moral things, moral issue that should be best left to the individual themselves to decide whether they want to do it or not to do it. I think we know this phrase, my body, my right. If you hear this coming from this, secular, liberal groups, now what they say that the state should not interfere, the state should not even try to legislate on matters of morality. Um, Now, what is the way forward? What is the way forward? Let's talk about the issue of morality. Now today we're talking about um, what gender dysphoria. Um, this is something to do with morality. This is something to do with whether we can defend morality in the a situation where the secular forces has been very strong and intense. How do we protect the social fabric of Muslim society in this kind of situation? Can we rely on the secular laws? If you follow the decision or the majority decision of the federal court, there's nothing to worry. Muslims has nothing to worry because law, the laws, what you call this, administered by the civil court, they're also takzir. Takzir means Islamic law. So why must we worry about it? Yeah, this is what they say. But as I said, that particular contention was quite problematic because in the same breath, the Chief Justice also said that the laws are secular laws. So how come secular laws become Islamic, or how come Islamic laws become secular? I cannot comprehend that. But the thing is this: no, secular laws will not defend or uphold moral values, as its very core philosophy is against state policing or enforcing morality. Yeah. So secular law has nothing to do with morality. Yeah? It is there just to maintain public order and peaceful functioning of the state as a necessary evil. This we know. I mean, those who study political science, those who study law, they know that this in the Western conception of the state. State is just a necessary evil. When the state punish murderers, this is not for the purpose of upholding morality. This is just to maintain order in society. When the state, punish traffic offenders, this is nothing to do with morality. This is just to maintain public order, to maintain peace, to maintain security. That's it. Right? It has nothing to do with morality. So it is wrong to equate secular law with ta'zir, which has religious and moral basis, or in Islam we call it akhlaq. You know, when the Islamic law in the state enactments punish, say, people who commit, khalwat, it is not just for the sake of punishment. It is, for the sake of upholding moral and religious values. This is the purpose of Islamic law. So I think the way forward, Muslims must understand Sharia and the objectives of Sharia or Maqasid al-Sharia. What are the Maqasid al-Sharia? The five Maqasid al-Sharia: protection of life, protection of property, protection of mind, protection of religion, protection of dignity, offspring. So when we talk about, say, LGBT, for example, why in Islam LGBT is haram? Because to protect dignity, to protect offspring, to protect marwah, yeah, dignity. Yeah. So, so that's why if you look from the secular perspective, what is wrong with it? What is wrong with LGBT? They don't harm anybody. Uh, the action, whatever they do, is between two consenting adults. Why must the state come in to say that is wrong and even to provide punishment for that action? No, they say no. They cannot comprehend that because from secular perspective, law is there to protect, just to protect public order, to protect peace, to protect security. to make sure that individuals don't harm others, that nobody will become victims. So in LGBT, for example, the practice is there is no victim, you know. But if you look from the Islamic perspective, that is not the sole or the only purpose of law. The purpose of law is also to protect dignity, to protect offspring, and therefore LGBT is haram. Yeah. So my thinking is this: if this, I would say that this onslaught of secularism of Islam getting more intense, we will see probably in 10 or 20 years, probably, well, LGBT will be legalized even in this country. Yeah. What more, even the Chief Justice has said that the structure of our federal constitution is secular, leans towards secular. So I think the way forward is Muslims must be aware of the onslaught of secularism in Islam. When we discuss about Nick Elin's case, we must put Nick Elin's case in this particular context. We cannot see Nick Elin's case in isolation from this context. Otherwise, we will not, understand the degree of, problem that you are facing. So I'm a bit critical of those, scholars or Muslim intellectuals here. There's nothing wrong with this. There's nothing to worry about this. I think there's some problem in their thinking by saying it. So I would like to end here, and probably later on we can discuss in the question and answer session. Right. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you very much, Dr. Mazuki, for that very good presentations. Thank you, Dato. So next, we will continue with our next speaker, Dr. Norazina. So later the question and answer session, we will bring it after we have finished Dr. Razina's presentations. So in the meantime, you can type your question in the chat box. All right. So the floor is yours, Dr. Razina.
Okay, Assalamualaikum warahmatullahi. First of all, I would like to thank Dr. Zahid and of course Chris for inviting me for this session. Okay, it is a very privilege to to have the same platform with Dr. Mazuki. Okay, so basically I'm sharing my slide right now. Okay, so basically this research is basically done with my friends, okay, Dr. Raja Madihah and of course Dr. Eng Sitiong. Okay, so actually Dr. Eng he want to come, okay, but then he has court cases today, so he cannot attend. Okay, but then alhamdulillah Dr. Madihah can come today, inshallah. Okay, she can also help me to answer the question later on. Okay, so basically before I will go, okay, why I'm doing the discussion, I'm also going to discuss case of Elin along the way. Okay, so right now when we mention about gender identity disorders, okay, so basically this research is about how the court in Malaysia, okay, treat those cases who involving GID. Okay, so right now, basically in 1960s, okay, GID basically been discussed, closely linked to mental health or psychosocial issues. Okay, but then later on with the continuous movement, okay, starting from 1990s, okay, which especially among the Western states, okay, where basically they try to recognize, okay, homosexuality as a form of rights or human rights. Okay, later on, okay, this GID, okay, which basically been defined as a disorder or illness, okay, that happen when a person who consistently display characteristic of the opposing gender because of discomfort with their biological gender, okay, which involving the feeling of discomfort with one sexual organs or experiencing a mismatch with one biological sex and gender identity. Okay, so basically after this movement which happened in 1990s, okay, it seems that okay later on, okay, they revise JID, okay, as gender dysphoria, okay, where basically it is instead of disorder, it is being treated as a distress or discomfort. Okay, and then the first revision actually been received in this is done by the American Psychiatric Associations. Okay, and then later on it is this kind of trend being followed by the World Health Organizations. Okay, and then of course the trend continued, okay, until they introduce civil partnership acts across the Western countries in recognizing same-sex marriage. Okay, and then if you follow the movement nowadays, okay, even they start to indoctrinate, okay, LGBTQ education, okay, to small children as young as 3 to 4 years. Okay, so basically when it comes to nation context, okay, so what happened in Asia, okay, so basically in Asia we have individuals with GID, okay, basically, okay, we have the first group, okay, where they realize that they have GID, but then they continue to live their life as normal as possible in their original genders, okay, and then in this first group I also include those who are doing the retransition, okay, who basically previously they acting, okay, like the opposing gender, but then later on they start to do the retransitions, okay, and then sometimes, okay, they're becoming really pious, okay, really close to their religion, okay, and then also we have a second group of those people who have GID, who basically continue to believe, behave, and even conduct themselves as their opposing gender, okay, and then these people basically been called, okay, in this common term as transsexuals, okay, and then this term transsexuals already been recognized, okay, by the American Psychiatric Association and even the World Health Organization. Okay, and then again, okay, this kind of, by having the ID, it is basically a form of a medical condition. Okay, and then in Malaysia, the transsexual individuals, okay, frequently known as maknah, okay, partner, okay, bapuk, pondan, and others, okay, and then basically these terms, these Malay terms, basically already been used, okay, since 1980s in Asia, okay. So right now, okay, what are the legal status of individuals with GID? Okay, basically under the general rules, okay, under the Malaysian laws, individual with GID, okay, who either consider themselves as transsexual or not, okay, they have similar rights and responsibilities, just like the same to all of us, okay, to follow the existing laws, okay, equal to the rest of all of us, okay, and then these existing laws includes and prescribes, okay, under the Federal Constitution, state enactments, and other existing laws, okay. However, when it comes to transsexuals, okay, basically, okay, there is no law or legislation in Malaysia that recognize the status, okay, and created rights of transsexual in Malaysia. Okay, so basically they have to a certain extent human rights, okay, as what being granted under fundamental liberties, okay, but then not up to the created rights, okay, such as right to marry, okay, because some of them tend to have this kind of inclination towards their own opposing genders, okay. So right now, based on our legal analysis, okay, from these cases, basically from the reported cases, okay, we have 4 types of legal cases, okay, basically involving GID, okay, before the Malaysian court, okay. First of all, request to change information of original gender to opposing or altered gender. Second, transgressing, okay, religious offences. Thirdly, limit legitimacy of marriage. And then fourth, sexual offences. Okay, so right now this is one of the case. Okay, this case is pretty sad case. Okay, so sorry, in this case, okay, we have Mr. X, okay, who basically undergone a sex reassignments surgery in Thailand in 2019, okay, where basically he undergone the sex reassignment from male to female, okay, even though of course he's biologically born as a male, okay, and then later on, okay, in 2011, okay, he changed his name to Miss X and made an application to the National Registration Department of Malaysia, okay, to change his original name from Mr. X to Miss X, and then of course the original gender in the IC. Okay, but then later on, okay, what happened here in this case, okay, basically the court rejected his application, okay, because there is no provision or laws in Malaysia which allows the change of gender stated, okay, on the IC, on the identification card, okay, and thus, okay, basically due to protection of the public interest, okay, so basically the court cannot allow this kind of application, okay. But okay, so later, okay, basically Miss X, okay, was frustrated by such ruling, okay. Basically he passed away, okay, due to the heart complication on, okay. So you can see here, okay, due to the consideration of the court in this case is depend on public interest, okay, and then secondly due to no provision or laws in Malaysia, okay, which allow such change, okay, in the IC. Okay, later on, okay, we have several other cases, okay, what kind of treatment, okay, how the court treat when there is an application, okay, involving person or individual with GID, okay. In this case of Christy Chan, okay, versus Ketua Pengarah Jabatan Daftar Negara, okay, we have this application made, okay, by this person, okay, again to change the information, okay, as stipulated in the birth certificate, okay, where he is a male, okay, because okay, he already done the gender reassignment, okay, surgery, okay, and then later on, what happened here, okay, the Court of Appeal, okay, dismiss, okay, his application, okay, because one, there is no sufficient evidence, okay, to support his application, which means that he is now a female, not a male anymore. Okay, and then thirdly, there is no evidence from the medical or psychiatric expert in Asia to explain on what is gender. Okay, and then later on, okay, from this case, okay, there is one specific test, okay, where the court need to apply, especially when facing, an application involving GID. Okay, Christy Chan test or medical test. Okay, in this next case, okay, case of our own, okay, basically in this case, same situation happened, okay, where basically the applicant want to change the information, okay, in her medical, in her formal document, okay, where basically here again the court, okay, dismissed the application, okay, where basically the court, okay, follow the test in the Corbett and Corbett, okay, 1970, okay, where basically again, okay, in order to determine one's gender is not only depends on what the applicant desire, okay, or what the applicant think, okay, but then it must also involve consideration of chromosome, okay, gonadal, genital, and of course psychological factors, okay. And then here Corbett test laid down the second test, which is chromosome test, okay. Next, okay, in pengarah jabatan Daftar Negara, okay, we can see that basically, okay, this case apply both tests, okay, which is the chromosome test and then of course the medical test. Okay, so basically in order to determine, okay, if someone is really having GID, okay, it is important to apply not only the medical test, okay, but then of course the chromosome test. Okay, so now we go to the second category of cases, okay, which is transgressing religious offences. Okay, so this is when, okay, Ni Elin case become really important. Okay, so basically in this Ni Elin case, it is stated that, okay, the state legislator, they have, okay, they have the full authority to legislate law, okay, as stipulated under the state list, okay, of the federal constitution. Okay, and then when it come to religious offences, okay, it must be purely religious in nature. Okay, so how can we determine what is meant by pure religious offences? Okay, so here the court basically relies on two tests, okay, which basically been explained, okay, in the judgment of Ni Elin. Okay, so the first of all, the first test is to check whether the state legislated offences in question, okay, basically religious offences, which cover the general characteristic of Aqidah, sanctity of the Islamic religion and its institution, or thirdly, one purely relating to morality in Islam. Okay, after they pass this first test, okay, they should go to the second test, whether religious offences is purely religious offences, okay, which means that can be applied only to Muslim, enacted only for the purposes of Islamic law or religious reason, cover the general characteristic, okay, and then of course falls under the authority of the state legislators, okay, as already governed under the 9th schedule, okay, which is under the state list. Okay, but then, okay, even though, okay, this is based on our analysis, even though if the offences, purely religious offences, can pass these two tests, okay, by following the case of Duzaili, okay, where the Court of Appeal in this case, okay, basically take a very liberated approach, where basically they, even though the question here is relating to Section 66 of Sharia Criminal Enactment, okay, even though it is basically relating to cross-dressing, when male Muslim did the cross-dressing, okay, even though it is purely religious, okay, still the court of appeal basically take an approach that it is basically basically it is the section itself is not valid, is null and void, okay, because it is in contravention of Article 5 clause 1, 8, and of course 9 and 10, okay, which means that it affects the right to life, okay, under the fundamental liberties. Okay, so we can see here, okay, in a long run, if the state legislators want to enact laws or enactment in the state, they have not only consider limb 1 and limb 2, but then they also have to consider whether it is basically in contravention with the fundamental liberties or not. Okay, but then however, alhamdulillah, in this case Duzaili basically been overturned, okay, by the federal court, okay, since the high court and of course the court of appeal basically doesn't have any jurisdiction, okay, to entertain the challenge on the constitutionality. Okay, and then again in Iki Mubarak, okay, which has of course been referred in case Ni Elin. Okay, again the petitioners was charged under Section 28 of the Sharia Criminal Offences. Okay, again engaging in sexual activities. Okay, where the race, okay, the issue raised in this case is issue on the the overlapping between this Section 28 with Section 377A of the Criminal Code, okay, or the Penal Code. Okay, so again here in this case Iki Mubarak, okay, Section 28 is declared unconstitutional. Okay, so basically when it comes to case Ni Elin, okay, it opened a very huge floodgate, okay, especially for anyone to question about section, okay, in the enactment, okay, even though they are basically already been charged, okay, under the basics, okay, under the legal maxim of common law, okay, those who come to the law, those who seek justice, those who seek justice, supposed to come with clean hand, Okay, but then you can see in this case of Iki Mubarak, even the Zaili, even though they already been charged, okay, it seemed that they can go to the federal courts, okay, and question about the incompetency or the consistency of the law, okay, in order to avoid, okay, from being penalized by Syariah court. Okay, so this is basically quite, quite very dangerous trend which is happening right now. Okay, and then thirdly, okay, this is the case relating to legitimacy of marriage. Okay, Alhamdulillah, so far in Malaysia, okay, following the Section 69D of Law Reform and Marriage and Divorce Act 1976, okay, basically a marriage must be between one man and one woman, okay, not between the same sex marriages, okay, same sex partners, okay. But then, of course, under the Sharia, it is obvious that marriage is exclusive only for male and female, okay, where a Muslim man has the right to marry up to 4 wives subject to his ability to provide for his wife, okay. And then, of course, again in corporate case, okay, which is, of course, even the principles in corporate case basically previously been followed, okay, even not only in Commonwealth country and also European Union countries, okay. But then later on, this corporate case was repealed, okay. The principle is not being followed anymore, okay, due to the introduction of Civil Partnership Act. Okay, as far in Malaysia, there's no reported cases or there is no challenges which is made, okay, under the Law Reform Act, okay, 1976. Okay, but then in 2005, okay, we have one couple who basically the wife basically went through gender reassignment procedures, okay, but then instead of registering the marriage under the Law Reform Marriage Act, they basically opted to customary marriage, okay, which means that they don't go for registration, okay. In 2017, okay, the latest news about this couple, they were basically trying to register their marriage in Australia, okay, not in Malaysia, okay. And then fourth, sexual offences, okay. Basically, sexual offences in Malaysia are majorly covered under penal code, okay. And then, of course, we can also refer to other existing laws, okay, such as Sexual Offences Against Children Act 2017, and then, of course, Minor Offences Act 1955. Okay, so basically, latest we have the case of Mr. S, okay, Mr. S in 2023, who basically, was charged with two counts of sexually communicating with 2 victims who were minor, okay, through his Instagram account, okay. So basically, he was charged, okay, with 2 counts of non-physical sexual assaults against the victim, okay. And then, of course, the charge was framed under Section 11 Clause 1A of the Sexual Offences Against Children Act 2017. Okay, so basically we can see from these cases, okay, just like all of us in Malaysia, okay, if they are transgressing the law, okay, they should be penalized, they should be charged, okay, under the relevant laws. Okay, same goes to us. Okay, so basically right now, okay, by having in the case of Kelantan right now, okay, since the the declaration made by the federal court, okay, through case named Elin, okay, so basically what will happen, okay, basically those enactments, okay, those enactments that have similar laws or equivalent laws in federal laws, okay, the charges should be made directly with the federal laws, okay, since the sections under the enactment is not void, okay. And then I list here, okay, this is statement by Dato' Baljit Singh, okay. When come to sodomy in Malaysia, okay, it is fall under Section 337B, okay, and then it is basically the laws maintained as it is, regardless of the judgment made, okay, in Ning Elin case, okay. And then you can see here, okay, actually Dr. Mazuki already summarized the details, okay, of the Ning Elin case very comprehensively, okay. So basically, as stated, okay, by Elin, okay, basically the application that they made, okay, is on the ground that the state government of Kelantan does not have the legislative competency to enact the laws, okay, due to the overlapping, okay, due to the overlapping between the enactments, sorry, within the sections of the amendment with the existing federal laws, okay. And then of course we can see, okay, there is dissenting judgment, okay, by Justice Abdul Rahman Sebli, where he basically take a very strict interpretation when it comes to locus standi, but then it seemed that okay, the majority judgment in this case take a very liberated, okay, very widely, extending, okay, the locus standi, okay, when presenting, okay, the case, especially when it comes to issue of incompetency, okay, between federal and state, okay. So right now I list down here, this is the list, okay, of the sections which basically been declared null and void, okay. So you can see that, okay, section 3 and 7, sorry, section 13 and section 30 of the enactment, okay, basically been declared, okay, being counted as religious offense, okay, and then this is valid under state list item 1 and article 11 and clause 4 of federal constitutions, okay. Because why? Because it is purely, okay, purely religious offenses, okay, based on the two tests just now, okay. And then for the rest, it is basically overlap, okay, it is the sections basically overlap with the federal laws under this stipulated list, okay. So basically I put very quite, easy to understand here, okay, inshallah, okay. So basically what we can learn, okay, what we can learn from this case, okay, basically, okay, those who are, having the ID, they are being treated as the same as all of us, okay. But then again, if the court, okay, so basically in when it comes to the ID persons, the person who having the ID, okay, basically they need to pass the two tests, not only the medical test, but then also the chromosome test, okay. But then however, in case of Dhysphoria, I believe that case Dhysphoria at the stage of court of appeal, okay, even though it is basically being revised again after the federal court, okay, basically case Dhysphoria is much more dangerous, okay, because why the court, okay, without doing this medical test and chromosome test, okay, automatically depend on fundamental liberties, saying that, okay, this the Muslim male can go for cross-dressing as part of protection of their life and the rest of the fundamental liberties, which is of course questionable, okay. And then of course again, okay, the offences, okay, under the amendment must be purely religious offences, okay. And then not just that, okay, it does not limit the state legislators of their power to legislate laws, okay. And then of course the Syariah courts and its operation are continuing as usual, okay. But then of course when it comes to the Kelantan Syariah criminal codes, okay, it can continue to be operated, okay. But then of course, okay, half of the section already been declared null and void, which is of course not applicable anymore, okay. And then lastly, I believe that the states, religious authorities need to have a strong collaboration, okay, with relevant federal organs, okay, especially after having this case, So basically, they must go directly, continue to have, to continue to protect, okay, the public interest of Kelantan people, okay, by directly referring to the federal laws, okay. And then this is something which I also want to mention, okay, when Muslims are holding the majority seats in the parliament, okay, a focus should be given in empowering Sharia among Muslim in Asia. This is supposed to be the priority, okay. And then the latest update, this happened yesterday, okay, yesterday. The latest news is basically as part of the empowering process, Okay, basically the Sharia Court Criminal Jurisdiction Bill, or RUU 355, okay, is basically will be tabled, okay, in the parliament this year. Okay, basically the Sharia Court bills will be expected, okay, to expand, the jurisdictions of Sharia Court. Okay, but then however we have to see what will happen next, okay, especially whether this bill can be passed, okay, through the entire process of the parliamentary process. Okay, so thank you so much for listening. Okay, I hope that we can have a very interesting discussion after this, inshallah. Thank you, Dr. Haid.
Okay, thank you very much, Dr. Razina. All right, very informative presentation. So by the way, Dr. Razina is one of the authors for our book, inshallah, right, on gender dysphoria. So she will contribute from the legal perspectives. Okay, so now I open the floor for the question and answer session. So I have one question here for Datuk Dr. Mazuki. From Dr. Nur Jannah Hassan. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Datuk Dr. Mazuki. Our federal court is based on Western secular legal premises. However, according to Malaysia's federal constitution, it is clearly stated that Islam is the religion of the federation. My question is, how much is being done to harmonize the two systems of laws above, as well as between the federal court and the institution of the Sharia court since Malaysia's independence in 1957? Thank you. So, Datuk, perhaps you can answer first, or you want to take the other question too?
Yes, I think I can answer this question first.
Right.
I would like to begin with this. When we talk about Malaysia, whether the basis is secular or Islamic, when it comes to the federal constitution, I'm inclined to say that we are a hybrid system. Is it? We are not purely secular, and we are also not purely theocratic. If you see in the federal constitution, well, we have secular laws like laws of gender crime, and most of the civil laws are secular. But the constitution also, like we have discussed just now, gives some powers to the state legislative assemblies, to make laws on the Islamic legal precepts. So the Sharia laws, it's also state law, and we have Sharia courts, to administer those laws. So if we are purely, secular, we won't have that system. So it is, to me, it is quite hybrid, in this sense, and to me that this hybrid system, meaning the coexistence between the secular law and the Islamic law in this country, has struck some kind of balance uh, in the whole, political and legal system, in this country. So everybody will say that, well, I have a share in it, Or for those who believe in, a secular life, they say, well, I'm quite okay with this. For those who, the Muslims, the conservative Muslims, they would say that, well, I also have a share in it, in this country and in the constitution, which I can relate to the constitution, because when we go for, say, for example, marriage, for example, we have an Islamic law that govern our marriage, and all sort of other, personal laws. So the Muslims in this country won't feel that they are marginalized, because they can find something in the constitution that relate to their religion, and same goes to those, with secular views, so they can also relate themselves to the constitution. So to me, this is a balance, to strike a balance. But as I said in my presentation just now, secular law and Islamic law, it is very difficult for you to reconcile those because philosophically they are different. They are antithetical to each other, right? So when we say about to harmonize Islamic law and Sharia law, to a certain extent, like we are talking about how to reconcile the irreconcilable. So this is not an easy task. It is not an easy job. But I would say that in our country, we have done good in this. We have done a good job. There are efforts to harmonize it. If I'm not mistaken, there is a committee under this MKI, the Majlis Kebangsaan Hari Awal Agama Islam, that looked into how to harmonize, the Sharia laws, with the civil law system, and also to improve, not only to harmonize, but also to look into improving the Sharia law itself. Because we know that Sharia laws, they are enacted by the states, and sometimes there are some inconsistencies between states. So therefore, while we talk about how to harmonize Sharia law and the civil law, there is also a subject to harmonize the Sharia laws among the states themselves. So I think this is an ongoing process. This is an ongoing process, and I believe after Nick Elin case, and we have to look into this matter more seriously. Now, because the way I look at it, in the federal court decision, in the Nick Elin's case, it seems that the balance has been disrupted. Yeah, the balance has been disrupted. I think for the first time in our history, that the federal court even ruled that our constitution leans in favor of secularity. Previously, there is no such thing. No previous judges has said so. Tun Saleh Abbas, they said that the law is secular, which is correct. The law is secular, but none of them has said that the structure of the constitution leans in favor of secularity. My worry is that you disrupt this balance. When you disrupt this balance, then there will be chaos. So the committee that has been set up by the government to look into this matter, they are given 1 year to look into this matter. I think they should look into this matter more seriously, and how to make sure that there will be harmonization. There will not be, the constitution itself will tilt towards secularism, which I think will obliterate the Sharia laws in this country. You see, so this is a serious matter. So I hope that the committee that has been set up by the government realize that this is the problem that we are facing, then try to bring back the harmony between the two, to bring back the harmony, because previously there is harmony, and now I'm afraid that later on there will be a disharmony when it comes to the conflict between the Sharia and the Islamic law. That will be my response for now. Thank you.
Okay, thank you, Dato'. So we have another question, inshallah, from Brother Muhammad Noor Derus. Can you please introduce yourself and then ask your question?
Okay, my name is Muhammad Noor. I'm a practicing lawyer. Okay, actually, 3 points. Okay, number one, I agree. From my basic understanding, substantive law, we lose because it's clear-cut case. And the former Chief Justice also have already discussed about the inconsistency between the state enactment and the constitution. Okay, I have no doubt about it. So my suggestion here, is it worth it for us to discuss at this moment? I elaborate my point. The reason here is why we are reactive. When the federal coalition says, okay, the Kelantan's state enactment is null and void because of inconsistency, then we discuss and then we critically analyze. But the problem here, maybe I blame the academician and I blame myself and I blame a lawyer, you see. They are not working in team, you see. As a practitioner, I'm a Muslim. Maybe my education background is not so good. The lawyer who received this case is a selected people, and they are not share their point with other lawyer who are going to contribute. So when lose the case, the lawyer says, let's pray something to get something from God and change the decision. But in actual fact, why the academicians are not work in tandem with the lawyer before presenting the case at the High Court. Sorry, at the Federal Court. So this is one point I want to ask you. Secondly, here is, forget what happened in the past. From my observation here is, this is the problem. When go to is Sharia jurisdiction, academician sort sendiri, as practitioner also sort sendiri. But when I discuss with non-Malays, they are discussing at court's canteen. They are so open-minded and difficult for me to defeat their argument, you see, but at least there is some effort. So can you comment about it? Or maybe I overlook about this point. The issue is there is no collaboration between an academician and a practitioner. That's all.
Okay, Datuk, perhaps you want to answer, or Dr. Razina?
Oh yeah, I think I want to respond to this. First, about substantive law that we have lost it. Yeah, I think I mean, you as a lawyer, I think you know that when you go to court, then both parties have their arguments. Also on the substantive law, then when the court decide in favor of one, then we have to respect that decision. There is no issue about that. And I think the state government of Kelantan also accepted that they have lost the case, and that's why they have formed a committee now to give their views to the MKI, chaired by the Sultan of Selangor. The purpose is how to strengthen Sharia law, and that includes amendment to the constitution. And I think this has happened in the past. This is not the first time that the court, strike down certain law for being inconsistent with the constitution. So what the government did in the past, not the government, the parliament, like Tun Hamid rightly said, no, the court has, has done its job. Yes, sir? So it is the job of the courts to interpret the law, the constitution. If you are not happy with the decision of the court, you go to the parliament. I think that's exactly what the committee, even the Sultan of Selangor, said. Let's look into the constitution and how can we amend the constitution in order to strengthen the position of the Sharia law. Secondly, I think it's not reactive. It is not reactive. It is something that is expected to do. Because we know that in the concept of separation of powers, well, the court has the right to interpret the law, but don't forget, the one who makes the law is the parliament. So now it goes back to the parliament, whether the parliament would amend the law or not to strengthen the position of the Sharia law. Secondly, why the lawyers are not collaborating among themselves. As I said earlier, that this is basically, this is not a normal kind of litigation. To me, this is a strategic litigation. A strategic litigation done by people who maybe their intention was to repeal, to get this law repealed. And not through the parliament, but through the court, through judicial legislation. If you remember, say for example, do you remember Ayah Pain's case, the Kerajaan Langit in Terengganu? I think in the early 2000s or late 1990s, they have started to gang up. I think those lawyers who are more inclined towards this secular thinking or secular what could it, they embrace this secular perspective about law. There are groups, they have taken this as their effort, through strategic litigation to challenge the constitutionality of those laws, in the court of law. And of course, there are also groups from Muslim lawyers that try to defend, the Islamic law. So we are not talking about collaborating here because we are living in a situation where there are two groups that have two different views or perspective or worldview about the law itself. And thirdly, I would say that people are questioning, why we come to this stage, why not, during the stage of, drafting the law, yeah, when all the state enactments, were drafted, didn't they look into this matter? Well, I believe that before the law was tabled in the state legislative assemblies, at least the state what do you call this, the Office of the State Legal Advisor, which is under Attorney General's, chambers, have a look into all the draft and to make sure that it is not inconsistent with the federal constitution. Haven't they looked into that, 10 years or 20 years ago? But anyway, I don't want to go into that because otherwise we are being pointing fingers, then we are not looking into the way forward and how to solve, this conflict. And I think the best way is just to look into ways and means of how to make sure that the Sharia laws in this country will continue to be respected, will continue to be strengthened, so that it meets its objective. What are the objectives of the Sharia law? The Markah said the Sharia just now. The five objectives of the Sharia that we believe in Islam can be protected. So that's my response to Cik Makno. Right. Thank you.
Okay, thank you, Dato'. Any more question to Dr. Razina, perhaps?
Okay, thank you, Doctor. I think thank you for the question from our brother just now. For me, as as a lawyer who become academician, for me it is all about lack of coordination. Because everyone are moving by their own, and then moreover, we don't have one specific, one centralized data or analyze all these cases. So if we can have that, maybe we can have a better approach to deal with this kind of issue. So this is, my humble opinion. Thank you.
Yeah, thank you, Dr. Razina. All right, so we have another
May
question.
I add someone?
I'm sorry?
Sorry, may I add two sentences? May I say something for two sentences?
Yeah, thank you. Yeah, continue.
Okay, that's why I want to suggest, why don't after this we make a resolutions, or the Prof Mazuki or the academicians suggest we must have to discuss about this with academician whatever, and I will propose with friend of mine, you see. But the problem is, no offense, okay, we are not united. Someone established Majlis Peguam Syar'i, okay, and another one established, okay, peguam-peguam Muslim. The actual respect, with due respect, they show sendiri. I'm a practitioner, I don't join them. So this one, we must think, and then after this, make a resolution. I do my job, you do the job, so finish. That's all, my suggestion.
Right, thank you, Mr. Muhammad Noor. Thank you for the suggestion. For now, we are publishing a book on gender dysphoria on our part, centrist. A few scientists will write a few chapters, and then a few human academicians from the human sciences will write from their perspectives. So inshallah, the book will publish at the end of this year. Hopefully, it can be a guide, okay, for the public to read, because we are going to rebuttal all the arguments, the secular arguments. So inshallah, that's our small effort, okay, in relation to this webinar. Thank you, Mr. Muhammad Noor. Okay, we have another question from Michelle Lee. Good afternoon. I have a question for Dr. Mazuki. Can you elaborate on how secularism can lead to the removal of deciding on morality in the courts, and possibly the legalization of LGBT or same-sex couples in 5 to 10 years? Considering that secularism is talking about the separation of religious institutions from the government, Sharia court will continue to exist in Malaysia, and secularism does not mean the absence of religion or morals in society. Do you get it, Dato'?
Yeah, thank you, Michelle. When I say, well, I'm not predicting, but the way I look at it, because I've studied judicial attitude, of our judges since since the year 2000. They were quite, conservative in the past, but now most of our judges has taken a quite liberal stance on many things. The issue of locus standi, for example, and then the interpretation of the constitution, and BSD, for example, the basic structure doctrine. Now, say for example, when Dr. Razina mentioned about the Negeri Sembilan case, even though that you can say that it is an offense, purely religious offense, but the court says, well, because it is against fundamental liberties, against the concept of equality, then that law becomes invalid, even though it was overturned later by the federal court. But when I mentioned that part of the majority decision in Nick Elin's case, which said that the structure of the constitution leans towards secularity, this is a very big question mark to me. What will happen next? If the court declares that the structure or the basic structure of the constitution is secularism, then what will happen to the position of Islamic law and also policies in this country? Because we have to know that in secularism there are many types of secularism too. If there are well, of course, separation of religion and the state, where religion becomes purely private matter, then the state will not interfere into it. I mean, that's fine. That is one type of secularism. But there are also type of secularism which militates against religion. You can see in some countries that even Islamic organizations, they were declared as unconstitutional or become illegal organization, because they are against the concept of secularism. Even in France, for example, it becomes illegal for Muslim women, for example, to wear headscarf. So even you look at secularism in the United States and secularism in France, you find differences in the practice. And now you look at Muslim countries in Bangladesh and even in India, for example. You look in India. India is a secular country. They have Islamic law that govern Muslim marriage, but they don't have Sharia court. So when Muslim in India, for example, they face dispute in their marriage, they have to go to the civil court to let the civil court interpret Islamic law and so on and so forth. So to me, that's like what Dr. Razina said. It opened a floodgate that we don't know what will happen in 10 years or 15 years or 20 years, in the future. Today we can say that, well, Sharia court is still there. But if you see, I don't know, Michelle, are you a lawyer? Yeah. If you read, okay, you're a student. If you read recent decision by a federal court, Yang Ahmad Arif Zainul Ali, for example, in the Indira Gandhi case, it said that even the federal court, under Article 121, have the judicial power even to look into matters that falls under Islamic law. Does it mean that in the future the federal court can even entertain decisions that has been made by the Sharia court if someone, say for example, challenge it in the civil court? What will be the attitude of the federal court judges? Say for example, in marriage, for example, if the Sharia court has made decision, jatuh talaq, for example, divorce, has been declared, and it is effective, right? But say one party disagree with that, and then they then file a judicial review. Can a judicial review be filed in the civil court, to question the decision of the Sharia court? Of course, we have Article 1211A, all right, but with this basic structure doctrine, we don't know. But even the court can declare that Article 1211A as unconstitutional. Why? Because judicial power, they would say that vested in the civil court. So the whole discussion or debate about this basic structure doctrine in this country, to me, it creates more uncertainty. Something which we can say for sure now we are not too sure what will happen, 5 years, 10 years, or 15 years, So that's why I said that, don't take it for granted that now LGBT is haram in Malaysia. Same-sex marriage is not, is not accepted. It's not legalized, not only for Muslim, but also for non-Muslim. There is no the law. There's no law that legalizes same-sex marriage for non-Muslim in this country. I'm not talking about Islam, the Muslims. I'm talking about Christians, the Buddhists, the Hindus. Christianity that doesn't accept same-sex marriage. But if the court says that the basic structure of the constitution is fundamental liberties, this is their right, it's their fundamental rights. If a man wants to marry another man, and the court say, well, this is their fundamental right. Based on the basic structure doctrine. What can we say? What can we say? So I think that's why I said today we talk about Elin's case, but maybe later on I think we have to look more details into the basic structure doctrine, and what will its implications on the Malaysian, legal system, not only legal system, but the social fabric of our society. We're talking about the social fabric of our society. Thank you very much.
Okay, thank you, Dato'. Dr. Razina, do you want to add on that?
Yes, Dr. Taking from our Dr. Mazuki just now. Okay, so basically, we have still, regardless how schooler is the court as they claim, to a certain degree, they still have they are still the guardian of justice, the guardian of rule of law, and guardian of morality. So even if we talk about purely scholarism, they still have discussion on scholar morality or scholar ethics. Okay, and then I would like to give an example here. Okay, recently we have also one section 498 under the penal code, okay, which been declared as null and void as against Article 8, okay, of the Federal Constitution, due to it seemed that it is basically not confirmed with equality between genders, due to this section basically make an offense, okay, make an offense for any man who entice married women, okay, which means that, okay, what happened in this case again, this man was charged under this section, okay, and then he goes to the federal court and then try to get the declaration that basically this is go against the fundamental liberties. Okay, so what happened? Okay, 1 week. Okay, basically, as a result of this case, okay, no man or husband of the married woman can make report, okay, police report, when someone tried to entice, his wife. Okay, so basically, what happened? Okay, 1 week after the declaration, the judgment made, okay, by the federal court. Okay, we had cases, okay, where basically a man, okay, with his friend, okay, give a very good beating of a man who tried to entice his wife. Okay, so you can see here, even though we have this kind of a judgment giving a prioritize on the fundamental liberties, okay, while ignoring the legal essence of the enactment, the legal essence of the section, the public still will take, okay, still will do, okay, because everyone wants justice, okay, so they will do what necessary, okay, to protect their rights, to protect what they preserve as justice. Okay, so for example, I would like to take another example, right, like in Russia. Okay, also allow same-sex marriage. Okay, but then it doesn't mean that these people who committed to same-sex marriage can just go happily around the country. Okay, they basically been threatened more than what previously happened. So this is something that we need to alert. So especially, of course, regardless of the reason, with due respect to the judgment made by the learned judge of the federal court, at least, please consider, okay, the public interest, what will happen to the society if we disrupt the balance, especially. And thank you so much, Doctor. Thank you.
Okay, thank you, Dr. Razina. Any more question to the speakers? I see we've got a few scientists here, of course, social scientists too, people from the public. Okay, in relation to what has been said by Mr. Muhammad Noor, I think yesterday the Prime Minister announced the effort to establish a body, just like what mentioned by Datuk Mazuki just now, consists of experts from academicians, among the academics, and also legal experts, lawyers. So, what is your opinion on this? Will it able to improve the current condition of our constitution or not? All right. Perhaps Dr. Razina can respond first. Razina? Oh, Datuk?
Yes, probably I can just respond quickly to that. Well, I hope the committee that has been set up by the government, which consists of experts, legal practitioners, academicians, and also experts in the constitution, that was tasked to look into the law and the constitution on this matter, particularly with the objective to harmonize, the existence of the Sharia and the civil law in this country following the federal court decision in Elin's case. Will come up with something, substantial. If, say, for example, the federal constitution need to be amended, then go for it. Amend the parts of the constitution that will clarify, because of course the court will be bound to interpret the constitution as it is. So therefore, if there are some parts in the constitution that need to be clarified in relation to the power of the state legislative assemblies to make laws on Islam, on offences against the precept of Islam, then clarify those matters. And also relating to the jurisdiction of the Sharia court. Say, for example, if there is a need to strengthen or clarify Article 1211A, to make sure that Sharia courts in the jurisdiction will not be, trampled upon, by the civil courts. Just do it, because I believe that the present government have 2/3 majority in parliament. So to me, with the 2/3 majority in the parliament, there will be no problem, basically, to amend the constitution. And I must also put this on record, like we have to be thankful that many of those experts come from UIA. Even the Dean of ICOL also on that committee, which I would like to congratulate, the ICOL, on that matter, or for the point. I believe that, these people, these experts, they have the same thinking as ours, so they also have the intention, a very clear intention, to make sure that the position of the Sharia law in this country to be further, strengthened and solidified. Thank you.
Okay.
Sorry, just now, Dr. Okay. In my opinion, actually, we need to continue to do the proper action, proper coordination, to empower Sharia, especially for Muslims. But then at the same time, we need to have a proper enforcement of the law, regardless whether it is federal law or state enactments. So for example, like case of Iki Mubarak, it is obvious that basically the enactment, section 28, basically already null and void. But then he still can be charged under the federal law. And then so far, basically, as the information that I got, basically the state of Selangor already did the police report. So what's next? So why there's no enforcement? And then not just that, we have several viral cases, which is very open, such as case of the recent one, Hot Daddy and all, been celebrated just like celebrity. What happened here? Where is the enforcement? So everyone must do their part. Everyone must do their rules. Okay, as for academician, okay, lawyer turning into academician, we can write as much as necessary, but then if there is no one reading it, there will be no meaning actually. So that's for me. Thank you.
Yeah, thank you, Dr. Razina. So, do you want to give a conclusive remark, Datuk, before we end?
Yeah, I would like to thank Dr. Zahid, Centuries, and all those who participate in this webinar. Uh, uh, this is a big issue, complicated issue. Probably 1 hour of discussion. Will not thrash out all this issue, but I think we have taken small steps. Towards uh, more impactful what do you call this, a solution to this matter. So I would like to thank everyone for being here this morning. Thank you.
Thank you, Dr. Razina.
Thank you so much. This is privilege for me. Okay, and then I hope everyone can basically learn something today. I also learned something today. Okay, and then most importantly, I would like to repeat this hadis. Okay, kulukum ra'in wa kulukum mas'ulun ani ra'iyatihi. Sorry, which means that all of us are leaders. We are basically responsible to those who are under us. So at least if we cannot protect the country, at least we can protect those who are underneath us. Thank you.
Okay, thank you for both speakers. Thank you very much. Very enlightening, eye-opening session, I hope. So, yes, many thank yous. All right. So, as I mentioned, actually the webinar, inshallah, the webinar will be conducted regularly. We will have more webinars in relation to our effort to publish a book on gender dysphoria. But the discussion, again, will not be limited to gender dysphoria issues only. It can be anything that are related to gender dysphoria, inshallah. We are also, inshallah, going to have webinars on AI and hikmah, the question between AI and hikmah. That one will coming soon, inshallah. All right, thank you very much for those who attended this session. All right, I will end the session with Tasbih Kafarah and Suratul As. Okay, thank you everyone.